This video is for informational purposes only. Section 2. Types of successions, intestate, testate, and small succession, and handling immovable property in Louisiana successions.
In Louisiana, a succession is required if the deceased owned assets worth more than $125,000, or if there's immovable property that needs title transfer, regardless of value. The process settles debts, identifies heirs, and distributes property. It's governed by the Louisiana Civil Code and must occur in a parish where the deceased lived or owned the immovable property. Key steps include filing petitions in court, inventorying assets, paying creditors, and obtaining a judgment of possession to transfer titles. For immovable property, this judgment must be recorded in the parish conveyance records to clear title for sales or inheritance. Delays can tie up real estate for months or years, so understanding the basics is essential for families dealing with property inheritance. Note that laws, such as those on heirs' property partitions, were reformed in 2024 to address co-ownership issues. Louisiana has three main types of successions, each with implications for immovable property. First, intestate succession. This happens when someone dies without a valid will. The state decides who inherits based on family relationships, starting with children, who get usufruct over community property if there's a surviving spouse, then parents, siblings, and so on. Separate property goes directly to descendants. For immovable property, this can create heirs' property, where multiple heirs own fractional interests, making it hard to sell without all agreeing or court intervention, potentially leading to disputes or forced partitions. Secondly, there's testate succession. Here there is a valid will specifying beneficiaries called legatees and often naming an executor. This gives more control, allowing the deceased to direct how immovable property is divided or sold, potentially avoiding disputes. The court validates the will, ensuring it's signed and witnessed properly before the executor proceeds. Then thirdly, there's a small succession. This is for estates that are valued $125,000 or less. The simplified process uses an affidavit if no will or if the decedent wasn't a Louisiana resident. It's quicker and cheaper for immovable property, but you still need to record the affidavit or judgment in the parish records to transfer title. If the property value pushes the estate over the limit, it may require a full succession. Key differences between testate and intestate. Testate follows the will for asset distribution, offering predictability for the immovable property, while intestate relies on state hierarchies, which may not match the wishes and complicate real estate titles. Immovable property, like real estate, is a core focus in Louisiana successions because our laws treat it uniquely. It's governed by Louisiana rules regardless of where the owner lived and when acquired. In any succession, you must describe the property in detail, community versus separate, in affidavits or petitions. Common issues include cloudy titles from undivided heirs' interests, which can prevent sales and loans. Always appraise real estate early, as its value affects succession type and taxes. If the property generates income, for example, rentals, the succession must manage it until distribution. In testate cases, the will can specify sales. In intestate, state law dictates division, often requiring court if the heirs disagree.